Thank you for joining us today for Encore Learning Presents. It's going to be a very timely topic this afternoon on the War Powers Resolution. I'm Laura Polari-Welbus, Director of Encore Learning, just with a couple of reminders. This is a webinar. We put questions in the Q&A. There's a little icon on your Zoom toolbar, and if you have a question, you can put it there. Today's presentation will be for about 45 minutes, and then we'll take questions. When you leave the webinar, there will be a survey, so please complete the survey to give us feedback about our Encore Learning events. And know that you can also turn on your live transcript if you would like that. And with that, I'm going to introduce Louise Kenny, our Special Events Chair, to tell us more about what's coming up and introduce our speaker.
Thank you, Laura. Hi, everybody. I'm Louise Kenny. Many of you know me from these presentations and also on the tours, since I'm a frequent tour goer, along with many of you. And welcome to our presentation today. We try to be somewhat timely in our presentations, and we certainly have a very timely topic for today about the War Powers Resolution. Before I introduce Professor Vladeck, who is our speaker from Georgetown University, I'd like to remind you again to put your questions in the Q&A. We will definitely get to all the questions. Also, upcoming for our next presentation online like this on a Monday is Hamilton, the Man in the Musical, put on by a well-liked instructor at Encore Learning named Dan Sherman. I think many of you know him. You might even have seen this before. It's worthwhile coming back for the information and also the wonderful music and storyline of the musical. So on for a more serious topic today, the War Powers Resolution. Professor Vladeck from Georgetown University is an expert on the Supreme Court. He recently wrote a best-selling book called The Shadow Docket: How the Supreme Court uses Stealth Rulings to Amass Power and Undermine the Republic. He's argued cases in front of the Supreme Court. He's a Supreme Court analyst with CNN. He's an expert specifically on the court, on the separation of powers, on the Constitution, and on the federal courts. So he is well versed in this topic. We are thrilled, Professor Vladeck, that you're here. And without further ado, oh, by the way, one other thing is please do stay on at the end for the survey to make sure that you can express your feelings about this presentation. So please do. Professor Vladeck, you're on.
Great. Thanks, Louise. Thanks so much for having me. And hi, everybody. I have some slides that I'm going to share. So let me get those up and going. I know this talk was sort of billed as a talk about the War Powers Resolution. I actually thought it would be useful to take even a bit more of a holistic overview of the separation of war powers under the Constitution, historically, all the way up to the War Powers Resolution, and then some of the big questions that we have facing us today. It's really hard to open a newspaper these days without seeing at least some questions about use of the military, whether it's the operation to arrest Nicolas Maduro in Venezuela, or the deployment of troops into our cities in Chicago and Los Angeles and Portland. The military is obviously a big part of our domestic policy conversation, and yet I think it's remarkable how much of the law is still not nearly as well settled as we might want it to be. So my goal is actually to basically do a presentation in three parts. Part one, we're going to talk about the original understanding of the war powers, both internationally and domestically. And then parts two and three will get us closer to today and to the questions that we are currently facing. So let's start with the original understanding. This is probably not a picture many of you will recognize, but this is a drawing, an artist rendering of an event called Shays' Rebellion. It's pretty common when we talk about the founding of the United States and the drafting of the Constitution that we revert to this idea that the new federal government was designed to basically be different from the monarchy, from the powers of the king in pre-revolutionary England. That's true enough when we talk about, for example, the Articles of Confederation, the first charter that bounded together the 13 colonies into a nation at the beginning of the American Revolutionary War. But actually, by the time the Constitution was drafted in the summer of 1787, things had changed quite a bit. And Shays' Rebellion, which was basically a version of a tax revolt in Western Massachusetts in late 1786 and early 1787 had really laid bare some of the profound inadequacies of the central government under the Articles of Confederation, the impotence of the central government, the inability to actually use military force in an emergency, and indeed, especially the difficulties that would arise when some of the mischief was being caused perhaps by members of the state militia, as was at least partly true for the Shays Rebellion and the Massachusetts militia. And so the result was the Constitutional Convention, which dealt with how to create a country that was both free and strong. And that's where we had the various allocations of military power. And before we get to the separation of powers, I think the most important thing the Constitution does when it comes to military power is it gives it to the federal government. So unlike in the Articles of Confederation, where the dominant military units were the state militias, the Constitution quite specifically contemplates that there will be a federal military and that the government, at least as a whole, would have the power to use the federal military, not just for war and other conventional conflicts, but for certain types of domestic emergencies. So let me pivot to the next slide because it's worth remembering and reminding folks what exactly the United States will look like at the time the Constitution was written. And so what you can see on the slide in front of you is, to the north of the fledgling republic was British territory, whether Nova Scotia or Quebec or what is present day Ontario. To the south was Spanish territory in the form of East and West Florida. To the west was what was known as the Louisiana Territory, also Spanish. And of course, all along the frontier, you also had Native American tribes who, for better or for worse, were often in various degrees of hostility with the settlers along the borders. What this meant, as lots of folks have long pointed out, including one of my law school professors, Akil Amar, is that one of the most important imperatives facing the drafters of the Constitution in 1787 was to create a country that was geostrategically strong, and that would have the ability to meet the geostrategic threats that it faced. And so that is, I think, where we start any conversation about the war powers. That one of the ways, perhaps the most uncontroversial way, that the founders set up a country with a stronger ability to use military force was by having it be a federal power in the first instance, not a state power. One of the things Article 1, Section 9 of the Constitution specifically prohibits states from doing is keeping troops in time of war, and is having their own navies. So all signs of the centralization of military power. All right, but we weren't just going to centralize military power. The Constitution also wanted to divide horizontally military powers between the new legislature and the president. And so if you look, for example, at Article 1 of the new Constitution, Article 1, Section 8, which is where the Constitution enumerates the different powers belonging to Congress, there are a lot of war powers. I mean, there are a lot of powers relating to the military. Obviously, the big one, the power to declare war, but lots of other ones. The power to raise armies and to provide for annual appropriations for those armies. Indeed, the one sunset in the Constitution's legislative powers is that military appropriations actually have to be annual. The power to make rules for the government of the land and regulation of the land and naval forces. So Congress would not just stand up a military. Congress would get to decide the rules that govern the military. What we today call the Uniform Code of Military Justice is in fact a statute enacted by Congress, not just a series of decrees by the executive branch. And perhaps most importantly on the home front, the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. So, in these clauses and others, the drafters of the Constitution gave all of the powers to Congress to figure out how large the military should be and to define the circumstances in which it could be used. If we pivot to Article 2 and the executive branch, we see a lot less. In fact, the only clear, even military adjacent power in Article 2 is the Commander-in-Chief Clause, which provides, of course, that the President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when they're called into federal service. What was this provision for? Why is it here? Well, in the Federalist Papers, speaking of Alexander Hamilton, although I don't know that Hamilton is so much more uplifting than today's topic, Hamilton wrote in Federal 69 that the title, the clause, the power of being commander-in-chief would amount to nothing more than the supreme command and direction of the military and naval forces as first general and admiral of the Confederacy. In other words, that the power the commander-in-chief clause was meant to create was a power of superintendence and civilian control of the military, not an independent power to use the military to whatever ends the president saw fit. So, if you just read the Constitution and knew nothing else about what happened in the 239 years since, you might come away with the conclusion that when it comes to the war powers, both domestically and foreign, the real stick, the real sort of font of authority rests with Congress. And indeed, that tracked throughout most of the early years of the Republic, really all the way up into, and I would even argue past, the U.S. Civil War. So on the foreign and international side, Congress authorized and funded both formally declared wars, like the War of 1812, and even more limited uses of force, like the power to capture French ships that Congress authorized during the so-called quasi-war with France. Indeed, there's very, very little, if any, examples in the antebellum era of any president claiming the power to use the military without pointing to at least some statutory direction and authorization. The same was true on the domestic front. As early as 1792, Congress passed a statute, now today known as the Insurrection Act, implementing its power to call forth the militia to deal with domestic emergencies. Now, in 1792, that statute was very limited. It required, for example, ex ante judicial approval before the president could use the military in at least some circumstances. But, everyone understood that it was Congress that was calling the shots. During the Whiskey Rebellion, another tax protest in 1794 in Western Pennsylvania, President George Washington followed the statute, the 1792 statute, to the letter. He never suggested that he could respond without the statute. He never suggested that he could deviate from the statute. Everyone assumed, basically, that Congress had occupied the field. And this understanding really persists all the way up to and even through at least much of the Civil War. For obvious reasons, the Civil War raised a host of new problems and questions about the president's war powers. And unfortunately, at least for academic purposes, it did not provide especially conclusive answers. The only real sort of development that set a legal as opposed to a practical precedent was the Supreme Court's 1863 ruling in a series of cases known to history as the prize cases. By the way, this is a picture of the in the basement of the Capitol, which is where the court sat up until the middle of the Civil War. Then it moved upstairs to the old Senate chamber where it sat till 1935, till it got its own building. Anyway, in the prize cases, the question was about the legality of the naval blockade that President Lincoln had imposed at the outset of the American Civil War. And by a 5-4 vote, the court upheld the blockade, but the majority opinion relied upon a bit of a mix of statutory authorities for the blockade and the idea that the president has at least some inherent defensive constitutional war power. Basically, that the president didn't have to wait for Congress if the United States was attacked, as it was at Fort Sumter in April of 1861. Okay, so just to it's a lot of history here, but the upside is that the clear founding era and the clear antebellum understanding was that the president was mostly carrying into force powers that Congress had delegated by statute, and that there was very little, if any, room for the president to go it alone, perhaps with the exception of the defensive war power that the Supreme Court first recognizes in 1863. Okay, let's move on to the 20th century shift. And to do that, it might help to spend a minute on terminology. So I just referred to the idea that the prize cases recognize an inherent defensive war power. Well, let's talk about a couple of terms that get thrown about a lot in this conversation. So when folks like me use the term inherent power, what we usually mean is that there are at least some circumstances in which the president can act unilaterally without clear congressional authorization. And so it's inherent in the sense that it is inherent in Article 2 of the Constitution. It's a power the president's allowed to wield unilaterally, even if Congress has not said anything, right? Basically, until and unless Congress occupies the field. The prize cases is, I think, a good example of this argument that when it came to playing defense, the president could act alone without waiting for Congress. That makes, I think, even more sense if you remember and recall that really up until the early 1900s, the 20th century, Congress was a part-time operation, right? Congress would convene usually every year in Washington in December and would stick around until its work was done, usually in March or April. Then it would go home. And so the notion that the president would have to wait for Congress in all events was somewhat inconsistent with the fact that Congress was often not around. Indeed, at the beginning of the Civil War, one of the first things President Lincoln had to do was call Congress into a special session because Congress was not in session at the start of the Civil War. So inherent power arguments really have a lot to do with that history, that there were just circumstances in which the president was all by himself and was in fact the personification of the entire federal government. And maybe the arguments were stronger that he should be allowed to act without having to wait for Congress. The shift in the 20th century and the source of so much of our contemporary mischief when it comes to the war powers is the rise of an even more aggressive set of arguments about executive power. These are arguments about what might be called either indefeasible or preclusive executive powers. And you see these terms used interchangeably. The difference between inherent power on the one hand and indefeasible or preclusive power on the other is, again, Congress. Inherent power is the idea that the president can act until and unless Congress steps into the fold. Indefeasible power is that the president can act no matter what, even if Congress has specifically prohibited the thing he's doing. This idea has virtually no supporting evidence in the antebellum era. There are almost no examples of debates over this, even in other pitched constitutional battles during the Civil War and Reconstruction era. It really is a creature of the 20th century and especially the post-World War II 20th century. And so what we really see is something that is often described as the rise of presidential war making, where after World War II, you have successive presidents of both parties, President Truman, President Eisenhower, President Kennedy, President Johnson, President Nixon, increasingly using military force on their own in circumstances in which Congress either hadn't expressly authorized it or any authorization was at best implicit, or Congress maybe acquiesced through funding, but where there was no clear, Congress says, yes, we can do this. So this was common in the early Cold War period as the United States intervened militarily in especially various countries in South America and Africa, et cetera. The Korean War was a little different because there at least there was a statute, the UN Participation Act, that President Truman claimed obligated us to help defend Korea from invasion. But really you start to see the, how do I say, the slow, steady growth of arguments that the president can go it alone. And obviously, the place where this really blows up is Vietnam. The Gulf of Tonkin Resolution in 1964 is a statute, obviously, Congress passes to authorize at least some hostilities in and around Vietnam. But by the time Congress even passes that statute in August of 1964, the U.S. had actually been quietly involved in at least some military operations, especially in North Vietnam, for years. So, what happened to Vietnam is you have presidents, again, of both parties claiming ever more power to act, whether because of the Gulf of Tonkin resolution, whether because of funding bills, or just on their own Article 2 initiatives. This sort of pivots in 1973. We'll come back to why 1973 is an inflection point. But what we might call the aggressive phase of presidential war making really starts in 1973 when President Nixon vetoes the War Powers Resolution. And he vetoes the War Powers Resolution, at least in part, on the argument that it's a violation of Article 2. Okay, so during the aggressive phase, what we really see is assertions of power on the part of the president to act, even if Congress specifically disclaims presidential power in those spaces, on the ground that any such statute, any statute purporting to regulate and otherwise limit the president's war powers is a violation of Article 2 and the rest of the Constitution. And this argument is first thoroughly developed with respect to the War Powers Resolution itself. So this is a picture of the War Powers Resolution as it was enacted over President Nixon's veto in 1973. So what is the War Powers Resolution? Well, it's a statute, obviously. It's a statute that tried to do a bunch of different things. So the first thing the statute tries to do is to reclaim Congress's power over unilateral war making by basically saying, hey, in general, presidents aren't allowed to use military force by themselves. And it creates a weird and I think, unfortunately, poorly designed series of procedural mechanisms to try to rein in the circumstances in which presidents can use military force without express congressional authorization. So, for example, it requires presidential notification to Congress within 48 hours, either before or immediately after troops have been introduced into circumstances in which hostilities are ongoing or are reasonably likely. It limits the use of troops in those circumstances to a maximum of 60 days, although there's a provision that can stretch that to 90 days. And it authorizes Congress to terminate any of the uses of force that triggered the War Powers Resolution by a concurrent resolution. That is to say, by a bill that passes through both chambers of Congress, but doesn't have to be signed by the president. As I mentioned, President Nixon vetoed the War Powers Resolution. His veto message made two different arguments for why the president was refusing to sign it. The first was the one I alluded to already, which is the Article 2 argument that Congress was interfering with the president's unilateral war powers. The second is an important but more technical one, which is specifically about the termination provision, which is that the termination provision, by allowing Congress to terminate presidential uses of force by a concurrent resolution, was a violation of Article 1, Section 7 of the Constitution, because it was an impermissible legislative veto. It was Congress retaining for itself the power to legislate without having to go through the president. In 1983, actually, the Supreme Court's going to say that that is indeed true, that those kinds of provisions are unconstitutional. Before we get there, so the title of the slide probably gives away the punchline, but the War Powers Resolution kind of sucks. The very well-known constitutional law scholar John Hart Ely wrote a series of articles, the title of which was Suppose Congress Wanted a War Powers Act That Worked, because in his view, this one didn't. And actually, those articles turned into a really lovely book called War and Responsibility, which if you find any of this interesting, I'd encourage you to check out. So why is the War Powers Resolution really, really problematic? So the first is the what we might call the Chadha problem, the 1983 case that struck down legislative vetoes. The termination provision is almost certainly unconstitutional, at least under current Supreme Court precedent, which really leaves Congress no immediate way under the statute to cut off any uses of force by the president, except by passing a new statute. And of course, the problem with such a new statute is that it would not just have to get through both chambers of Congress. Presumably, the president would veto such a statute. And so you would need veto-proof supermajorities of both chambers to actually rein the president in. That's just the first problem. The second problem, the statute does not provide clear criteria for its critical trigger for when something does or does not count as hostilities, for exactly what kinds of situations trigger the president's requirement to notify Congress and start the running of that 60-day clock. This was exploited famously by the Obama administration in 2011, when it argued that some of its operations in and around Libya did not trigger the War Powers Resolution because what was happening in Libya was not, quote, hostilities, unquote, within the meaning of the War Powers Resolution. I did not find that argument especially plausible, but the unfortunate reality is that the War Powers Resolution does not conclusively reject it. Third, the statute does not provide an obvious mechanism for enforcing it. So separate from the termination provision, the statute does not empower anybody to sue to enforce the statute. So there's no obvious mechanism for courts to enforce it. There are no funding cutoffs that are tied to the statute that requires separate maneuvering by Congress. And so the statute is basically almost entirely hortatory. It is an exhortation to the executive branch to generally follow the law, but with very few penalties, at least legally, if the president thumbs his nose at it. And perhaps worst of all, right, the statute can be read, has been read, may be read to implicitly acquiesce in unilateral uses of force by the president during the 60-day statutory period. After all, as the argument goes, if the statute only cuts off uses of force after 60 days, what's the president allowed to do during the first 59 days? So you add all of these together, and it's pretty easy to see why almost every president, I think we can leave Jimmy Carter out of the story, but almost every president since 1973 has found ways to basically comply with the War Powers Resolution by writing their way around it, or by having the lawyers write their way around it. The statute really has proven mostly toothless over the course of the 53 years it's been on the books. Okay. On that uplifted note, let's turn to sort of where we are today and the current controversies, because as you might have gathered from the last few minutes, the War Powers Resolution is not really that central to too many of our current controversies. Instead, I want to talk about 4 different war powers problems that we are currently facing and that we have been facing for some time, and then at the end talk a bit about potential solutions. So let me start with problem number 1. Problem number 1 is actually not a constitutional problem. Problem number 1 is a statutory problem. We've talked about how Congress can and historically has often authorized the use of military force and has delegated to the president broad power to do so. Today, one of the most important examples of that is a statute known in my very nerdy universe as the Authorization for the Use of Military Force, or the AUMF. This is the statute Congress passed literally 3 days after 9/11. When we still didn't even know, or at least when there was no public accounting yet about who had attacked us on September 11th. And you have the entire operative provision, Section 2A, on your screen right now. You can read it yourself. I will read it out loud. The president is authorized to use all necessary and appropriate force against those nations, organizations, or persons. He determines, planned, authorized, committed, or aided the 9/11 terrorist attacks, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. So this is not, as the media sometimes portrayed it, a declaration of a war on terrorism, but it's pretty close because it gives so much power to presidents of both parties, again, to decide who the statute applies to. The obvious ones, of course, are Al-Qaeda and the Taliban in Afghanistan and along the border areas of the Af-Pak border. But actually, again, President Bush, President Obama, President Trump, and even President Biden have used this statute as the basis for military force against a number of other organizations with, at best, loose connections to Al-Qaeda or the Taliban, and in lots of countries that are, at best, loosely connected to Afghanistan and Pakistan, including in the US. Right, that this statute's been on the books for almost 25 years. It's about to have its 25th college reunion, I guess. And Congress hasn't touched it once. And this is so even as executive branch lawyers of both parties have interpreted it to mean ever more capacious things and to apply in ever broader theaters. So, when we talk about, for example, drone strikes during the Obama administration, that really wasn't so much a question about the constitutional separation of war powers. It's a question about the AUMF. And the Obama administration invariably tied its power to use military force in those cases to this 60-word statute that Congress passed 24 and a half years ago and hasn't touched since. That's a big problem. And whatever you think the right answer to our military policies should be, it seems like leaving this on the books as almost a blank check probably is not it. Also why there are some folks, and I'm one of them, who think that all use of force authorizations should have sunsets. This one did not. Okay. Problem number 2, speaking of the war powers, Article 2. So we have been pretty lucky, and I'm going to come back to this theme at the end of my presentation, to avoid a whole lot of sort of head-on confrontations about the scope of the president's Article 2 powers. But the Supreme Court we have today is perhaps more supportive of a broad reading of Article 2 than any of its predecessors. And that's manifested in a couple of ways that bear directly on the war powers. So first, of course, is the decision in July of 2024 in the presidential immunity case, Trump versus the United States. Now, it might not seem obvious at first blush how a decision about the president's immunity from criminal prosecution bears on this war powers conversation. But recall from a few minutes ago that so much of the war powers debate is about the extent to which Article 2 gives the president indefeasible and or preclusive power. In Trump versus United States, the Supreme Court embraced as aggressively as it ever has before the conclusion that the president has indefeasible inherent powers, indefeasible preclusive powers that extend, among other things, to control of the cabinet and to control of the executive departments. That is a powerful argument for any attempt by any president to claim that statutes limiting his uses of force are unconstitutional. Just to go back to the Bush administration for a second, folks might recall that when the first reports of, for example, torture at Abu Ghraib and other detention facilities came out in the summer of 2004, and later when we learned about what certainly appeared to be unlawful warrantless wiretapping on Americans, the Bush administration's response was not that Congress had authorized any of that behavior. It was that the statutes specifically forbidding that behavior were a violation of Article 2. The Supreme Court never directly passed on those questions. Now, here in 2024, the court's saying, oh, actually, the Article 2 argument has legs. Related to that, on the right now, we also have the court in the context of the president's control of executive officers, also endorsing the idea of what's come to be known as the unitary executive theory, that Article 2 gives the president all of this power over the executive branch, that Congress lacks the power to regulate at all. Again, that's not directly about the war powers, but it certainly emboldens the president and enables arguments about presidential power that we have not seen historically, that really have not had support in the past. This is why, among other things, we've seen the Trump administration resort ever more aggressively and ever more quickly to Article 2 when explaining why they're using military force abroad and not to some contorted statutory interpretation. Third, I'm full of good news today. At the beginning of this year, we saw the president send troops into Venezuela in this remarkable operation to arrest President Nicolas Maduro and bring him back here to stand trial. So it's remarkable. The Trump administration's legal position with regard to the Maduro arrest operation is that it wasn't really a use of military force at all. Rather, the argument that we've heard, at least indirectly from Secretary Rubio and from a few other Trump administration officials, is that the real justification for this operation was the view that under Article 2 of the Constitution, the FBI, the president has the power to direct the FBI to make arrests on foreign soil, even when the foreign sovereign does not consent. That is to say, to violate the sovereignty of foreign sovereigns to make an arrest. And then, and this is perhaps the best bootstrapping argument I've heard in a very long time, of course, the military can accompany the FBI when it goes into these other countries without their permission to make these arrests, because heaven forbid someone might shoot at the FBI officers who are, after all, invading those foreign countries. This is a remarkable effort to basically have the tail wag the dog. And to use the very dubious claim about the FBI's extraterritorial arrest power as a pretext for sending in troops. It's not hard to imagine how, if this were to become a precedent, it could be expanded into lots of other contexts where the president could try to, use the sort of specter of an arrest warrant as a justification for sending the troops into lots of countries. I don't think that's what the founders had in mind when they drafted the constitutional split of war powers. Okay, and then last but certainly not least, we also have the increasing use by the president of federal troops and the threats to use federal troops to carry out law enforcement in U.S. cities. And this is all about the Insurrection Act and those founding era statutes that allow the president to use military force when it comes to domestic emergencies, to suppress insurrection, to repel invasion, to execute the laws of the Union. What you're seeing on your screen right now is a picture of the last time that troops were actually deployed domestically under the Insurrection Act. It was in 1992. You can maybe half make out where that post office is in Los Angeles, California, in response to the riots arising out of the Rodney King beatings and then the trial and the acquittals. I don't want to sort of spend too long on this all. I'm happy to go into more detail in the chat, and the Q&A afterwards. To make a very long story short, presidents historically have been pretty responsible about using troops for domestic law enforcement. Basically, the two circumstances historically where we've seen presidents use troops in a domestic capacity have been when local authorities have been overwhelmed and have asked for assistance. And the 1992 Los Angeles example is a good example of that. Or when local authorities are themselves responsible for why the laws are being obstructed. When, for example, local or state officials are refusing to enforce desegregation orders. So President Kennedy, for example, sent the military into Mississippi in 1962 to protect James Meredith, the first black student at the University of Mississippi. President Eisenhower sent the military into Little Rock in 1957 to enforce the Supreme Court's decision in Brown versus Board of Education. Those were really the two categories. And there's actually a really useful memorandum written by then Deputy Attorney General Nicholas Katzenbach in 1964 that walks through this whole history. Um, the problem is that the reason why those have been our two examples historically is because presidents have been willing to observe not just legal but political constraints on their ability to use troops domestically. Because if you actually were to just read the plain text of the Insurrection Act, you might be surprised at how broad it is. It allows the president to use troops, at least in theory, whenever two or more people, that's what you need for a conspiracy, are obstructing the enforcement of federal laws. So if, three people get together and put, I don't know, spikes outside of the garage at the ICE facility in Minneapolis, or, park broken down cars right in front of the garage entrance, or otherwise do anything to impede ICE officers in the carrying out of their duties. That is technically, at least if you read the statute, like wildly out of context, arguably within the scope of the statute. Presidents haven't invoked it because, one, the political costs of doing so have been very high. President George W. Bush famously did not invoke the Insurrection Act to help send troops into New Orleans after Hurricane Katrina. But two, it's also because we really do have a very strong tradition in this country of not using troops for domestic law enforcement. There's an 1878 statute known as the Posse Comitatus Act that prohibits the use of the military for law enforcement unless Congress has specifically authorized it. That's why the Insurrection Act is a big deal. It's an authorization for it. And indeed, President Trump's efforts last year to federalize National Guard troops without invoking the Insurrection Act and to send them into Los Angeles and Portland and Chicago was actually blocked by the federal courts on the ground that he couldn't do that without invoking the Insurrection Act. Indeed, the Supreme Court in December left those lower court rulings intact. And so we have this problem where there's political constraints historically, where there's reason to believe that the Insurrection Act does not allow the president to use troops in these circumstances, and yet where the letter of the law itself is at least ambiguous on this front. And because we haven't had that many episodes historically in which presidents have used this power in a way that was controversial, we don't have a lot of case law. There hasn't been a lot of litigation as to the scope of the president's power under the Insurrection Act and its limits. And so when we think about the war powers today, like one of the biggest questions is not just how the president has claimed ever more power under Article 2 when it comes to foreign uses of the military, but the very real specter that a president might try to use the Insurrection Act to deploy troops domestically in a way that we've never seen before, and in a way that I think would be deeply antithetical even to the founding era conceptions of why we have a military presence. Okay, so that's sort of the four big buckets of contemporary problems, debates, issues arising out of the war powers. And you might have noticed the war powers resolution did not figure that prominently in any of them. Turns out the war powers resolution was a pretty bad statute if your goal was to actually rein in or at least clarify the circumstances in which the president could use military force. So here's a couple of sort of bigger takeaways. Takeaway number one. If we look at American history, I think what we find is that presidents, and especially American history since 1945, presidents of both parties have claimed ever more power to act, both unilaterally, so by themselves, and preclusively, so even in the face of statutes, especially as Congress has become increasingly feckless. There's this old line about Speaker of the House Sam Rayburn that Aaron Sorkin, I think, borrowed in a West Wing episode. And the line is about a freshman member of Congress who gets to Washington, D.C., who finds Speaker Rayburn and who says, Speaker Rayburn, Where are the Republicans? I want to meet the enemy. And the speaker puts his arm around the freshman and says, son, the Republicans aren't the enemy. They're the opposition. The Senate, now that's the enemy. We don't think like that anymore. Congress does not operate like that anymore. I mean, we really do live in a time where the separation of parties has become far more important than the separation of powers. And so the result has been to enable in a massive shift of power from Congress to the executive branch, not necessarily because Congress is specifically authorizing presidents to do what they're doing, but because Congress is not pushing back when presidents are claiming ever more power to act on their own. That is a huge problem that transcends the politics of the moment, and it's perhaps the biggest issue facing our contemporary war powers today. But before we sort of suggest this is a pox on both your houses and everything is terrible, I think there are some important respects in which over the last 12 months and 3 weeks, President Trump is already acting in respects that go beyond what any of his predecessors, including he, had argued and done. We're seeing more aggressive invocations of Article 2 arguments as a basis for using force. We're seeing this bootstrapping theory about using the military to support extraterritorial arrest operations. We're seeing the president resist even ordinary congressional oversight of how these war powers are being deployed. And of course, on the home front, we've seen unprecedented and ultimately illegal efforts to deploy the National Guard. And we're at least seeing the president threatening on a regular basis to use the military domestically, to invoke the Insurrection Act, et cetera. And I think what should not be hard to take away from all of this is that especially as Congress continues to be indolent and to sit on its hands, the pressure on courts to intervene in these cases and in these contexts is only going to grow. I mean, I think 15 or 20 years ago, and I have a quote that I'm about to share with you that I'll get at this. I think the courts would have been perfectly happy to sit out of all of these cases. But one of the real themes of the last 12 and a half months is that the courts really have been it. And as between having no check on the executive and having the deeply imperfect check of judicial review, courts have at least thus far opted for the latter. There's every reason to believe that if this pattern continues, if we see further drift of war power, further lack of pushback from Congress, the pressure on courts to intervene in these contexts will only grow. So this is where I wanted to sort of bring things full circle. So in 2008, the Supreme Court, in a case called Boumediene versus Bush, held that Congress and the president had gone too far in trying to keep the federal courts out of the Guantanamo habeas litigation. And this is from the very end of Justice Anthony Kennedy's opinion for the majority in that case in Boumediene. Kennedy says, because our nation's past military conflicts have been of limited duration, it has been possible, he writes, to leave the outer boundaries of war powers undefined. And just to be clear, what he means is undefined by the courts. If, as some fear, terrorism continues to pose dangerous threats to us for years to come, the court might not have this luxury. This result is not inevitable, however. The political branches, consistent with their independent obligations to interpret and uphold the Constitution, can engage in a genuine debate about how best to preserve constitutional values while protecting the nation from terrorism and other threats. The word I love the most in this quote is can. The political branches can engage in a genuine debate. I think the problems we are facing today can almost all be tied to the extent to which that debate has disappeared. And we are no longer really having a public debate about the war powers, as opposed to a public debate about whether a Democratic president or a Republican president should be stopped from exercising them in a particular way. Obviously, there are reasons why that's the debate we're having, but I think that in the long term, that's to the bad and that's to the detriment of the constitutional separation of powers in our system. Separation of war powers shouldn't depend upon who the president is, shouldn't depend upon what party he belongs to, shouldn't depend upon what exactly the president's using the powers for, should depend upon the Constitution and what it says. And I think part of why we've gotten so far away from that is because of exactly these pressures and these developments. And one of the, I think the sort of the challenges for all of us today is how we get back. So this is why I often write about the war powers and these domestic issues in my newsletter called One First, which is at least ostensibly about the Supreme Court, but it's about the Supreme Court and related issues. You can find it at that website or through this QR code. It's also why I really, really appreciate the chance to speak with audiences like you, and it's why I'm really looking forward to taking your questions. So thanks so much. And with that, I think we can, Louise, pivot to some Q&A.
Thank you, Professor Vladeck. You gave us a lot to chew on, that's for sure. Um, First of all, please do ask the questions in the Q&A, and I will get to them. I would like to kick things off a little bit. And by the way, your newsletter is in the Q&A, so please look there, and also on Substack, in addition to what Professor Vladeck put on there. So a lot of this seems to be dancing on the head of a pin with a lot of these. I mean, they're very similar, a lot of these different laws. Um, and is it just determined which one will fly? Which one they'll even hinge the argument on in a given conflict situation, like Venezuela, like potentially Greenland could have been if there's an invasion. They just try to figure out the most saleable one?
I mean, I think I don't know. So let me start from the beginning. I think um, the president needs like, any one authority. There's no requirement that you have like more than one authority. And so I think there's an inevitable pressure on executive branch lawyers to find legal justifications when they're available. Um, the problem is that those justifications are supposed to be meaningful. They're not supposed to be sort of retrofitting, like after the fact, post hoc rationalization. So, there's a famous quote by the Scottish writer Andrew Lang, who was criticizing the way that economists use statistics. He says they use them the way that drunks use lampposts, which is to say, for support, not for illumination. I worry that increasingly these days, executive branch lawyers use these authorities for support, not for illumination. And the reality, Louise, is that they're not supposed to be a potpourri, right? The different authorities are supposed to be specific to different problems and specific contexts. And I think what we're seeing, especially from the Trump administration, is the idea that like Article 2 is just a catch-all. That if there's no more specific statute, the president can just invoke Article 2, wash his hands of it, and be done. That's not how we've thought of Article 2 powers ever. It's not even how President Nixon viewed Article 2 powers. And I think the problem is that if you take that argument to its limit, not only does that mean the president can do almost whatever he wants, but it also means Congress can't stop him. And it seems like that, it's that last part, Louise, that I think really turns the original understanding of the war powers on its head.
Okay, thank you. We have a question from Richard here. Did some of the major shift in power occur due to the 17th Amendment?
It's a good question. I mean, the 17th Amendment, which provides for the popular election of senators as opposed to elections by states, I think the 17th Amendment certainly restructured the role of the Senate and how the Senate was and was not accountable to state legislatures. I don't know that there's any really good scholarship on how that had a direct impact on the war powers, because the reality was that, the 17th Amendment um, predates most of the major shifts in the war powers by the better part of 30 years. It's really after World War II, right, that we start to see all this pressure on the executive branch to act more and more by themselves. And I guess, Louise, I mean, I'm a law professor, not a political scientist, but at least my amateur understanding of the political history here is that, Congress in the 1940s and 50s was still pretty, how do I say, institutionally responsible, right? I mean, not in every moment, but that Congress, at least you had, conservative Democrats, you had liberal Republicans, and so you had plenty of opportunities to build coalitions across party lines when it came to Congress asserting its institutional prerogative at the expense of the executive branch. I think the real problem is that Congress was like, I don't know, sort of sufficiently unbothered by what the early post-war presidents were doing, by what Truman and Eisenhower were doing, that you had this sort of slow accumulation of power that Congress just didn't really sort of stand up and start fighting about until Vietnam. And by that point, I think, presidents could point to really 20 to 25 years of acquiescence by Congress that really watered down efforts to hold them accountable. I mean, I didn't talk about this in the presentation. Louise, there were dozens of lawsuits filed during the Vietnam War in which different litigants tried to get the courts to rein in what, Presidents Johnson and Nixon were doing. And the problem that those lawsuits kept running into over and over again is the courts looked at Congress and said, where's the clear repudiation of what the presidents have done, right? Where is the clear lack of acquiescence in this behavior? And the only case where even one court finally tried to put its foot down was the bombing of Cambodia in 1973, when Congress had basically cut off all funds for the bombing of Cambodia. And even then, I mean, the courts really didn't enforce the funding cutoff until the day after it expired, right? Until the day after it went into effect. So, Congress passed a statute on, I think it was July 1st, cutting off funds for the bombing of Cambodia. It says no more funds after August 15th. So courts say, oh, well, until August 15th, go bomb. Which is not what Congress meant. And so we really, I think Vietnam was an inflection point because it drove home how hard it would be for the courts to unilaterally police the executive, and also how much Congress had lost the thread when it came to asserting itself across party lines in clear, emphatic, power restraining ways versus the mush that we got in the War Powers Resolution.
Steve asked the question, is some of the major shift in power, I'm sorry, I'm missing. Does the War Powers Act or the AUMF apply to cyber warfare as well as hard regular warfare?
It's a messy question. I mean, so I'm going to do the AUMF first because that's easier. I mean, the AUMF presumably says necessary and appropriate force. It doesn't say it has to be kinetic. And so presumably a universe in which we were under a threat of cyber attack from Al-Qaeda or the Taliban or other groups that were responsible for 9/11, you could make a non-frivolous argument that the AUMF would authorize us to retaliate. The War Powers Resolution is messier because I think, there's not an obvious body of precedent for the proposition that cyber attacks are hostilities in the conventional sense of the term, or that cyber attacks at least necessarily implicate the war powers. I mean, we can think, Louise, of two different kinds of cyber attacks. A cyber attack that just shuts down government servers for a day versus a cyber attack that causes a physical manifestation where power plants explode or a dam releases its water, right? Like those are very different, I think, from the perspective of war powers. And there's been a sustained effort by experts, by scholars, by academics over the last 25 years to try to rationalize these two things, to create sort of laws of cyber warfare. There's something called the Tallinn Manual, which is named after the capital of Estonia, that tried to come up with some universal principles. But, I think the reality is that so much of the cyber side of this happens out of sight and in areas where it's at best, Louise, covert, that these legal theories have not been well developed.
Jean asked the question, why doesn't Congress use the power of the purse to cut off funding for unauthorized military operations by the executive branch?
It's tried. I mean, so that was how, for example, the Cambodia bombing was finally stopped in 1973. There are two problems here, right? The first is trying to get Congress to defund military operations is kind of like trying to get Congress to defund ICE, right? It is at least until a month ago politically toxic. It might still be politically toxic if it's more viable now. The other problem is, right? Louise, appropriations bills are still bills. And they have to be both approved by both chambers of Congress and signed by the president. And, we've seen veto threats from presidents who have said, I'm not going to sign this if you try to cut off these funds. In fact, what Congress has done instead is it's used funding cutoffs for other measures. So, for example, the reason why there are still 20 people at Guantanamo is because since 2011, Congress has barred the use of funds to transfer people out of Guantanamo. So, constitutionally, Louise, I think nothing is stopping Congress from funding cutoffs. It's the politics that have historically been the problem. And I think that's very much why we're not seeing more of that today.
Arnold asked, will you be making the materials for us available? Yes, we are recording this, so we definitely have that. Your PowerPoint, can you make that available to us as well?
Sure.
Professor, great, thank you. Lynn asked the question, with deployment of troops into the U.S. cities, do you see the usage of casus belli provoking and justifying escalating troop attacks on U.S. citizens and others?
Um, so I mean, I think there's a lot there. I guess I'll say two things. I think that there's no question in my mind that the Trump administration um, would have been all too happy if any of the more aggressive uses of military force and or deployments of ICE had led to a clear sort of provocation where, it wasn't just that it was people like Renee Good or Alex Preti being killed, but actually like a use of force against, ICE officers themselves. Luckily, I think we haven't seen that. I mean, we really haven't seen the kind of, I think, provocation that the administration was perhaps looking for. Whether they were waiting for that, whether that just would have been a happy coincidence. I mean, I think folks are going to have to keep their own counsel about what they believe on that front. I'll just say, I think, it is meaningful that that hasn't happened. I think it's a sign that the administration still is at least subject to some political checks, that it hasn't invoked the Insurrection Act already. I also think, and this is maybe going the other direction, um, the administration has been able to do with ICE and with other federal law enforcement personnel a lot of what, it might have thought a year ago it wanted, it needed the troops for. And, this is, I think, one of the real sort of tragic ironies of the moment we are in, which is that if the troops were the ones who were actually enforcing these laws, um, frankly, I think the troops would be better at it. And I think we actually would see sort of fewer violent confrontations between, armed federal officers and protesters if the federal officers were well-trained members of our military, as opposed to, not especially accountable officers in ICE and other immigration enforcement areas.
Thank you. So Eileen asked the basic question. So how do we fix all this?
How do we fix this? Well, I think the
Your
first thing
magic
to
wand?
say,
Do you have a
um,
magic wand here?
I mean, I wish I had a magic wand.
Yeah.
The first thing I'll say is, I mean, just having this conversation is a good start. I think we don't talk nearly enough about the nuances in our war powers. Um, I think we are all guilty, Louise, to some degree, of the same thing Congress is guilty of, which is conflating the separation of powers and the separation of parties. Um, so I think problem number, we have to start there with sort of reclaiming the institutional powers of our institutions. Um, Step two, I think, we are so inclined these days to vote for people based on our sort of domestic policy priorities. And we don't vote for people because they're institutionalists. And I think, we need a generation of elected officials, whether it's at the state level or the federal level, whether it's in the presidency or in Congress, who are running not on a particular social platform, but to restore the separation of powers. Vote for me, and I will, in Congress, support legislation to rein in the executive branch, no matter who the president is. Might be a surprisingly popular platform in 2026 and 2028. So I just think it's a mindset problem, which is that, we have been sorted into our political and ideological beliefs to such an extreme that there's very little appetite, Louise, for the kinds of structural reforms that are needed, except in circumstances in which they're not possible. So when you have, for example, a Democratic majority in both chambers of Congress, but a Republican president, you can't get these bills through a filibuster in the Senate, and you certainly don't have veto-proof majorities for them, and the other way around. When there's a Democratic majority in Congress and a Democratic president, everyone's focused on substantive policy, not institutional reform. And so I think it's just, we have to remember, we have to go back to first principles and to civics and to sort of start with the separation of powers and, have faith that the better accountable the branches are to each other, the better position we'll be in to deal with all of these issues in the long term.
Thank you. Janet asked the question, and makes a statement and then asks a question. In the early 1980s, Eddie Boland, congressman from Massachusetts, attached an amendment to a spending bill prohibiting use of the funds provided for any military or other attacks or activities with respect to Nicaragua, including not supporting opposition militias known as the Contras. It seemed effective at the time and ultimately led to the Iran-Contra affair in trying to find a slippery means to get around the Boland Amendment. If it could find support from enough members, couldn't a similar amendment or provision now be included in spending bills?
Absolutely. Right. But the question is, how do you get that support and how do you make that a priority? I mean, so we're seeing this right now, Louise, with the fight over DHS funding, where, part of why the DHS appropriations bill has not gone through on a permanent basis is because Democrats and a handful of Republicans, right, want to use the funding bills as a way of exacting at least some leverage over DHS. But you know what already happened? We already passed the DoD funding bill. And so it's going to be another year, right, before we can have that conversation. But this is the point. I mean, Janet's exactly right that this is how we should be thinking, is pushing members to wield their powers over the funds and over the money and over the purse, to tackle all of these questions and to impose real constraints on the executive.
Thank you. Many of the things that President Trump has done, he's done through executive orders, right? So we don't get into the constitutionality in terms of legislation. And he very much says, even if how many people comment that things are unconstitutional, he says, yeah, so what, right? I mean, he doesn't get too worked up about it. When somebody has that attitude, can you do anything on that? It reminds me of Andrew Jackson saying with the Indian Displacement Act, well, let then Congress send in the troops. And of course, they don't have the power of sending in troops. So how do you get away from an attitude of, so what? It's unconstitutional. So what?
In my experience, the folks who have that attitude only have that attitude when presidents of one party are in office, and not when presidents of the other party are in office. I'm not aware of anyone who consistently believes that it's unconstitutional, so what, no matter who the president is. So the first thing to say is they're hypocrites. The second thing to say is, John Adams was right. We have a government of laws, not of men. And the way that the reason why the Constitution matters, the reason why the separation of powers matters is because that's how we ensure subject to the rule of one person's whim. That's how we can be sure that the president has good reasons, right, for doing what he's doing.
Okay, thank you. Thank you. It's certainly upsetting. And of course, then with the immunity from last year, combining with that attitude, it's a tough one, right?
That's right.
Thank you very much, Professor Vladeck. This was absolutely terrific and so timely. I'm like amazed at how timely it is, and that you very graciously came to talk to us about it. So thank you very much. I wanted to remind everybody. Oh, I see applause going up on the screen here. So your talk was very much appreciated. I want to remind everybody to take the survey to provide Professor Vladeck with some feedback from this presentation. I also want to remind you to come on the 23rd and listen to a presentation about Hamilton the Man and the musical. Professor Vladeck, it's open to the public, so if you would like to do that, I can send you the link, and you can do that. And actually, I should clarify, this is not online. This is at the Arlington Library, but it's open to the public. So please come then. And with that, I think I'll close us out. So this was excellent. Thank you very, very much for very enlightening. And also, everybody, we will make this slides available. We'll communicate exactly where the slides are, and then we'll also have the link on our YouTube channel for the professor's presentation. So with
Thanks,
that,
Louise. Thanks, everybody.
Well, thank you again. It was a pleasure. Thanks. Bye-bye,
Bye all.
everybody.
The YouTube recording will be online tomorrow, and when we get the slides, we'll provide a link to the slides at the link for the YouTube channel.
Okay, great. Thank you, Laura.
Yep.
Bye, everybody.
Okay, bye, everybody.